Welcome back. We're in the middle of our discussion of the Warren Court and the Warren Court Revolution. We've talked about three prominent areas of case law that revolution involved. It's segregation, the segregation decisions in 1954, Brown versus Board of Education, and its companion case, Bowling versus Sharp. We talked about a series of cases in which the Warren Court came to apply, to incorporate, that's the phrase, the Bill of Rights against state and local governments. We talked about a landmark free expression case, New York Times versus Sullivan, in which the court upheld the right of Americans to engage in robust, uninhibited, and wide-open freedom of speech, including sharp attacks on government officials. So today we're going to talk about three other areas of Warren Court case law and pull the camera back and talk about the Warren Court as a whole. So another famous and controversial series of cases of the Warren Court involved prayer in the public schools, and the court basically eliminated organized, state-run, school-sponsored and directed prayer in the public schools in a series of cases in the early 1960s. Engel and Abington are two of the important cases here. And so where does the Constitution say that, Professor? Well, the Constitution does, in the First Amendment, talk about the free exercise of religion and the idea that there should be a federal establishment of religion. Now recall that, of course, thanks to incorporation, these basic principles, insofar as they're principles of liberty and equality and freedom, as opposed to mere states' rights, these basic principles apply against states as well as the federal government. They're incorporated. And now think about organized prayer in the public schools and ask yourself, is that really consistent with full religious liberty and equality, which are the fundamental principles? When the government is writing the prayer, well, whose prayer is it going to write? Is it going to write a Christian prayer? Well, not everyone is Christian. Is that really equal? Even if it writes a Christian prayer, is it going to write a Protestant prayer or a Catholic prayer? If we're going to do Bible reading, are we going to read from the King James Bible or the Catholic, the Douay Bible? How's the Apocrypha going to be treated? Which translation are we going to use? So now government, when it makes all these decisions, is picking sides. It's choosing one religion, and often within that one sect, one prayer to privilege, to advantage over the others. And at the very least, if government tries to do that, students of different faiths have a right to not participate in that. They'd have a right to be excused. It was, obviously, they can't be. No one can be compelled in America, really, to engage in a religious worship ceremony contrary to their own faith tenets. So at the very minimum, you would have to actually excuse folks of other religions. But here's what would happen when you did that in the public schools. You'd have to, in effect, be segregating students at that moment of prayer on the basis of basically their religious beliefs. Some people would have to stand up and stand out from the others. And this was a court, remember, very sensitive to the social meaning of segregation, of the government dividing kids up particularly. So remember, this is the court that earlier in the Warren Court era has given you Brown versus Board of Education and Bowling versus Sharp. So I think the same kind of sensitivity to the ways in which segregation could itself be unequal, calling attention to certain distinctions among people. Some are born lighter skinned than others. Some have different faiths than others. And the basic thought is government shouldn't be in that business. That is a violation of the deep idea of religious liberty and equality. It seems to me that's a very plausible understanding of our constitutional precepts. Perhaps not compelled. There might be other interpretations. But here, I think, as elsewhere, the case law actually buttresses, supports, clarifies the constitutional text. It's a useful lens or prism through which we can engage the text. Now, I have a different view about the so-called exclusionary rule. Under this rule, that the Warren Court, that dated the Warren Court, that first appeared in Supreme Court case law at the beginning of the 20th century when the federal government was involved, but that the Warren Court extended to states in an early 1960s case called Mapp versus Ohio. This principle basically is as follows, that if the government, state or federal, according to the Warren Court, it's extending it to this principle of the states, if the government acquires certain evidence against a suspect, and that evidence is acquired in violation of the Fourth Amendment, then that evidence can't be used in a criminal case against that defendant, even if the evidence is completely 100% reliable. It's the smoking gun, and it's got the defendant's fingerprints all over it. It's the bloody knife with the victim's blood, with her blood on the blade, and his bloody fingerprints on the handle. Even if it's completely reliable evidence of guilt under the exclusionary rule, it can be tossed from the case, and the guilty defendant may walk free, grinning, much to the chagrin and the horror of the victim and or her family. I'm using gender here because often criminal victims are women, often perpetrators are men. And the question is, where does the Constitution say that? And my answer is, it doesn't. It doesn't in any of the ways, actually, and it doesn't in any of the ways, the proper ways of going beyond and beneath and behind the Constitution while remaining faithful to it. So the Fourth Amendment's text doesn't say anything about exclusion of evidence. And no framer of the Constitution said anything supportive of something like the exclusionary rule. The universal rule at the founding in federal courts and in every state court, and most states, you see, have Fourth Amendment counterparts in their state constitutions, was reliable evidence comes in. In English, that's always been the rule of England. In fact, here's a sentence from an English judge. It matters not how you get it. If you steal it, even, it would be admissible. The question is it reliable? So no founder, the text doesn't say exclusion. No founder thought so. For the first 100 years in America, no court, state, or federal, first 100 years after the Declaration of Independence, no exclusion anywhere in America. As I said, that's never been the British rule. And you say, okay, well, Professor, fine, so it's not in the text. But you yourself believe in going beyond the text in all sorts of ways. Yes, I do. So, is a right of exclusion implicit when we read between the lines? Is it a sense? I say when we read between the lines, here's the principle. We protect innocent people against the possibility of erroneous conviction. So, yeah, the text doesn't say a right to have an appointed lawyer. And actually, that wasn't the uniform early practice. But without a lawyer, you might be innocent and nevertheless convicted. And we don't believe in that. That's not. The system is designed to sort the innocent from the guilty. And in order to do that in today's world, everyone needs a lawyer. And if you can't pay for it, we pay for it. The government pays for it, because that's central to innocence protection. Yes, the text doesn't say you have a right to introduce reliable physical evidence of your innocence, but that's innocence protective. So we should do that. Yes, the text doesn't say proof beyond a reasonable doubt, but that will protect a possibly innocent person from being erroneously convicted. That's the deep constitutional provision. So when we read between the lines, it's about protecting innocence, not guilt as such. And the exclusionary rule protects the guilty as such. Well, we talked about another principle, the lived constitutional principle, about looking at how counting practices and learning from bottom-up customs and understandings of the citizenry. When Gideon versus Wainwright was decided by the Warren Court, 45 of the 50 states already gave criminal defendants paid attorneys. So it was already in all felony cases. And other states, actually, of the 5, gave them in some subset of cases. So when the Winship case was decided, almost everywhere you had proof beyond reasonable doubt. When the court affirmed that a defendant had a right, criminal defendant, to take the stand in his own behalf, almost all the states had already done that. Those things were part of the lived Constitution. Not so with the exclusionary rule. When the court extended the exclusionary rule to the states, the Warren Court, actually most states where most Americans lived did not have comparable exclusionary rule principles. And where states had exclusionary rule principles, these had basically been concocted by judges, often without strong popular support. And so as actually we're going to see, interestingly, this one area, the exclusionary rule, is not only the area where the Warren Court was most strayed furthest from a proper understanding of the unwritten Constitution. It's also been the one area where later courts have pushed back the hardest. So this is the one thing, the exclusionary rule, where the Warren Court legacy actually has been weakest. In the other areas, as we're going to see, later courts have actually endorsed the Warren Court vision in the other 5 areas when it comes to segregation and incorporation of the Bill of Rights against the states and broad protection of free expression and religious liberty and equality and voting rights, which is the other area. So now let me talk about voting rights for just a minute. The Supreme Court affirmed a broad right of people to vote and to have their vote counted equally. One person, one vote, an end to malapportioned state legislative systems where, let's say, a hamlet of 1,000 people sent one representative to the state capitol, in the state legislature, and right next door, a city of 20,000 people also sent one representative. So massively unequal apportionment before the Warren Court, and the Warren Court ended that saying, nope, representatives represent people, not trees or acres. That's a direct quote from Chief Justice Warren in a famous case called Reynolds versus Sims. And the basic idea, the take-home of that is one person, one vote. The districts have to be pretty much equal size for congressional seats within a state, for state legislative seats, both the lower house and the upper house of the state legislature. So the state Senate can't be malapportioned. Can't treat counties, give counties equal weight if they were of different populations. The way the Senate, the U.S. Senate, does give states actually equal weight even if there are very different populations. California is a lot more than Wyoming. In the U.S. Senate, Wyoming and California count equally, but that you can't do that at the county level in any state Senate. Reynolds versus Sims says basically that in elections for the state assembly, the state senate, and also in another Warren Court case for congressional delegates, the districts have to be pretty much equal sized. And where does that come from, you say? The court said the Equal Protection Clause, but now you know enough to know that that's a little tricky because equal protection was about aliens who weren't even citizens. It's sort of an odd way to talk about the right to vote. The framers of the 14th Amendment didn't think that Section 1 was really about a right to vote. That's why you needed the 15th Amendment. 14th Amendment was about race discrimination, but not in voting. Elsewhere, civil rights, not political rights, not about voting. That's why you needed the 15th Amendment, which was about race discrimination in voting. That's why you needed the 19th Amendment, which is about sex discrimination in voting. If equal protection did all the work and said no discrimination in voting, boy, the 15th and the 19th Amendment weren't even necessary. So what the Warren Court said, equal protection didn't quite make sense, but it did. These cases did make sense to the Constitution as a whole. The Constitution 5 times after the Civil War talks about a right to vote. And in Section 2 of the 14th Amendment, it says if there are deprivations of the right to vote, there has to be a penalty paid. States should get fewer representatives in the House of Representatives in the Electoral College. And since they've never paid that penalty at all, actually, I think the text says if they don't pay a penalty, then everyone has to vote and vote equally. And if they're not voting equally, or if they're not voting, a penalty must be paid. They should get fewer seats in the House and the Electoral College. But since they're not getting fewer seats, no discrimination in voting. Everyone has to vote, and the votes have to be counted equally. And by everyone, the 14th Amendment, Section 2 said, male citizens who are resident and adults and non-felons. Now, after the 19th Amendment, male doesn't mean male anymore. It means male or female because the 19th Amendment is about women's suffrage. And the 14th Amendment actually says 21. That was the age. But after the 26th Amendment, that's now 18. But the basic presumptive base is adult citizen residents get to vote. And the 14th Amendment, Section 2 actually says that. And actually these Warren Court cases really do affirm that. And think about what would happen if you didn't have some principle of equal voting. Would it be okay for example, a legislature to come up with apportionment rules? So the 51, let's imagine a legislature of 100 seats. So the 51 senior members of the legislature, they each have their own little district, and they vote for themselves. So now they've got a lot, they've got a majority. And the entire rest of the state is divided up among the rest of us. Well, that can't be right. That's not a Republican form of government, a government from the people. And so if that can't be right, then there have to be some limits on the ability of states to malapportion. And the Warren Court announces the limit. And one easy enforcement rule is just count the votes equally. And you know what I just did? I slipped in another constitutional clause. Did you notice it? I mentioned the Republican Government Clause, Article 4. Yes, at the founding, that clause wasn't very vigorously enforced because slaveholders wouldn't have wanted the federal government to monitor too closely how they counted slaves or didn't in state legislative apportionments, or how they treated free blacks or didn't let them vote. So before the Civil War, I can understand that the Republican Government Clause had a very narrow reading, possibly because the antebellum South wouldn't have wanted robust federal enforcement of this idea of Republican government. But we saw in earlier lectures that during the Civil War itself, and especially right afterward, in the very process by which the 14th and 15th Amendments were adopted, Congress embraced a very broad reading of the Republican Government Clause. Now, states are going to have to be held to very high democratic standards. That understanding, that new understanding of the Republican Government Clause was baked into the constitutional cake, so to speak, was part of the very process that gave us the Reconstruction Amendments. And I think the Warren Court is picking up on all of that. It says, well, Congress read the Republican Government Clause very broadly in the 1860s, but there's nothing in that clause that says only Congress can enforce it. So it's permissible for federal courts to protect voting rights very vigorously in the 1960s, building on that same fundamental precept that after the Civil War, there's an important federal role in making sure that states meet very high standards of democracy and Republican government. The court called that equal protection. I would have preferred, because equal protection is about persons, aliens, not citizens, and voting is all about citizens, really. I would have preferred that they had called it the Republican Government Clause, or Section 2 of the 14th Amendment that does say the right to vote shall not be abridged. And unequal counting of votes is an abridgment of sorts. Okay, let's sum up. So I think that in the voting area, the Warren Court pretty much got it right, as it did in segregation and incorporation and free expression and religious liberty, but not in on the exclusionary rule. Let's just take a step back. And I'm going to tell you a little bit about this picture. This is Earl Warren. And as I said, it's conventional to refer to Supreme Courts by focusing on their Chief Justice. He wasn't the only person, obviously, in the Warren Court. Alongside him was a great senator, former senator. He was a Republican governor from California. And along him, there was a former Democratic senator from Alabama, Hugo Black, and a former New Jersey Democrat judge, William Brennan. So a northerner, a southerner, a westerner. A northern Democrat, a southern Democrat, a western Republican. A governor, a senator, a judge. This triumvirate, Brennan, Black, and Warren, together really lead the Warren Court. And the world is transformed. Let me just remind you what the world looked like before Earl Warren took over. Massive racial segregation, American apartheid ruled huge portions of America. Jim Crow reigned supreme. Many states disfranchised blacks with impunity. and had been characterized by massive malapportionment without, and in many cases the malapportionment was very much racially based. White rural areas were overrepresented at the expense of black urban areas, black cities. The Bill of Rights didn't generally apply against the states. Many states had gotten away with suppressing free speech, and the court hadn't always reliably and consistently stood up for free speech, even involving core political expression. State organized prayer was commonplace in the public schools. Criminal defendants had precious few constitutional rights that judges protected. That's the world of 1953. And it's not our world. That's an unrecognizable world. In the course of 16 years, Earl Warren and company revolutionized our constitutional understandings. So there is no Jim Crow today. There is no massive malapportionment and deprivations on the kind of scale that existed in 1953 of the right to vote today. There's no organized school prayer that's sort of widespread and everywhere today. The Bill of Rights generally does apply against the states. Broad protections of free speech are really the law of the land, robust, uninhibited, wide open. Now, the exclusionary rule still exists, but it's actually been cut back. So it's the one area where courts in American culture actually have been a little skeptical of the Warren Court. And it's interestingly the one area, I think, where the Warren Court really kind of made things up. So here's the bottom line. It's very interesting. The critics said the Warren Court is making up all this stuff. And the defender said, well, who cares if it is? These are good rules. Mine's different. My defense is different. In general, the Warren Court was faithful to the written Constitution. Often it used the wrong clause. On voting rights, it said equal protection. It should have said the right to vote is Section 2 of the 14th Amendment, Republican government. On incorporation, it said due process is the reason that we incorporate these rights against states. It should have said the privileges or immunities clause of the 14th Amendment. Applying racial equality principles against the federal government, it didn't say the first sentence of the 14th Amendment doesn't have the state. It just says equal citizenship. It didn't always give the best arguments quite, but it did channel the deep spirit of the Constitution. And one of the reasons it didn't always give the best arguments is giving the best arguments would have sometimes required overruling precedents. And as it was, the Warren Court overruled a lot of precedents. And maybe it was afraid to overrule even more precedents in doing the right thing. But the amazing thing is, today, these very controversial Warren Court decisions actually provide, are pretty much accepted by both sides of the political spectrum. Let's take Brown. Everyone today thinks Brown is right. Conservatives, as well as liberals, affirm Brown. Liberals say Brown stands for racial integration and robust and and the importance of education and equality everywhere. And conservatives say Brown says government shouldn't be in the race classification business, even when it comes to affirmative action. They are both claiming Brown, different interpretations of Brown. The conservative one, no affirmative action. The liberal one, education and integration. Let's take applying the Bill of Rights against the states. The conservatives have bought onto that. They say, oh, by the way, if you're going to apply free speech and free exercise and search and seizure and compulsory process and double jeopardy, if you're going to apply the First Amendment and the Fourth and the Fifth and the Sixth and the Eighth against the states, the Second Amendment too, please. Conservatives actually in the Roberts Court applied the Bill of Rights, the Second Amendment, read it in the individual rights way, and applied it against the states in a case called City of Chicago versus McDonald. They're buying into the incorporation project, actually. Let's take freedom of speech. Liberals say Congress shouldn't target legal aid attorneys that it doesn't like and try to defund them. And conservatives say, well, we believe in free speech too. Citizens United. Government shouldn't be manipulating campaign finance laws to protect incumbents. So both of them are accepting New York Times versus Sullivan. We have a kind of a liberal and a conservative interpretation of New York Times versus Sullivan. Let's take voting rights. Liberals and conservatives both believe in voting rights. They had different accounts of that in the case of Bush versus Gore. But in Bush versus Gore, the Republicans on the court actually were affirming, were echoing some of the voting rights cases of the Warren Court. I think they were misreading what some of those cases said on their facts, perhaps, but they were both, conservatives and liberals, pledging allegiance to the voting rights cases of the Warren Court. When it comes to religion, the conservatives say, okay, we buy the idea that no prayer in public schools, but if you really believe in religious equality, then we shouldn't be discriminating against religion either. And if everyone else gets a voucher for private schools, religious private schools should also participate in the voucher plan. And if all the other clubs, student-organized clubs, can meet after school, then the Bible study should also be able to meet after school. Because if the real idea is religious liberty, well, we shouldn't be discriminating against religion, but that's accepting the basic precepts of the Warren Court. We are not going back to organized state-sponsored prayer in the public schools. So in area after area, with the exception of the exclusionary rule, actually, I think the court has really accepted the basic teachings of the Warren Court. Here's Earl Warren. He was, we come back to the picture as we always do at the end of chapters. He was governor of California, big sunny guy, in Sacramento. Now, when he's governor of California, there's a youngster in California whose house Earl Warren visits multiple times. This youngster actually, I think, is a state page, a legislative aide in the California Capitol in Sacramento, where Earl Warren sort of presides over everything. That youngster's name, Anthony Kennedy. And he's now the swing justice on the Supreme Court. And so in the person of Anthony Kennedy and in many, many other ways, I think you see the enduring power, the continuity of the Warren Court vision in various ways. And again, there's a conservative interpretation and a liberal interpretation, but both sides actually, in all sorts of interesting ways, claim the Warren Court. Who would have thunk it? Well, we're not done yet. Lots more to cover. In particular, here's the key fact about the Warren Court. It overruled a ton of precedents, more precedents really than any court before it, about half as much as the entire period before the Warren Court. So in our next couple of lectures, we're going to try to think about what the Constitution has to say about precedent and what precedent has to say about the Constitution. Stay tuned.